So I just saw a post that Wendover Productions is suing Honey and PayPal in a class action lawsuit, and I just had to get this to you first thing. So let's take a look at what's going on. It's the beginning of a much longer effort to hold Honey and PayPal accountable for what they've done. If they have actually done anything wrong in the contract sense, in the legal sense. Certainly, I think we can all agree that the scam of it, the misdirection of it is unethical or immoral, but we kind of expect that from corporations in a capitalistic society. But still, it was probably some kind of misleading that none of the influencers knew that Honey was doing this. And it seems like maybe Linus Tech Tips figured it out a couple years ago and just quietly separated their relationship with Honey, as you do when you are operating a major media enterprise. You can't go around upsetting everyone. So, let's take a look at what was filed. So it's been filed in the United States District Court, Federal District Court for the Northern District of California in the San Jose division. Well, that's exactly where a major company like PayPal or Honey is going to be. Wendover might even be somewhere there. I don't know. We'll see in a moment when we get to that part of the lawsuit. So this is Wendover Productions versus PayPal, because I guess Honey is part of PayPal, maybe not a separate entity. And it's a class action complaint for intentional interference with contractual relations, intentional interference with prospective economic relations, and for injunctive relief. Basically, business relations. Plaintiff Wendover Productions and Businessing LLC plead on their own behalf and others similarly situated as a class action make the following allegations. Plaintiffs are content creators who earn a substantial amount of their revenue through contracts for promoting products and services. Plaintiffs are paid when they send followers or subscribers to purchase the products of their contractual partners. The final step of the transaction that pays both the contractual partners and the plaintiffs through a commission is a checkout page on a web browser. Plaintiffs have affiliate links which tell their partners this sale was sent by me. It is the same as a salesperson getting acknowledged when the customer goes to the cash register. This was the analogy made by was it Megalag that exposed this thing in the first place. This case involves a scheme by defendant to unlawfully supplant affiliate links from content creators with its own affiliate links via Honey, thereby redirecting commission or tracking on those affiliate links to defendant. So if you're not familiar with this scam, I'll put a link to Megalag's video or the big video that everybody was watching. Honey is a browser extension where you can look for coupon codes. Well, when you go to look for the coupon code using the browser extension, it changes the affiliate link. It even changes the affiliate cookie. So this means that Wendover Productions has an affiliate link. Well, Honey replaces the affiliate link with Honey's affiliate link, gives the customer the coupon discount, which it turns out there's also shenanigans there where the website and Honey have control over which coupon codes the customer sees. So you can actually direct Honey not to show a coupon code if you wanted to, as far as I understand from the video that I saw. So if this is true, then they are taking away the affiliate link and keeping that affiliate link money for themselves in addition to whatever else they make money off of in their company. Defendant PayPal owns Honey. Honey is a browser extension which purports to find consumers the best deal at checkout by scanning for discount codes. Content creators whose commissions were redirected are entitled to damages under tortious interference theories. Defendant via Honey has standardized practices and procedures which all content creators are subject to. The appropriate vehicle for recovery is this class action lawsuit. So we are in San Jose district. Venue is proper. A substantial portion of the events happened in this district. Defendant has its principal place of business in this district. Honey is a browser extension free to consumers which purports to automatically look for discount codes when consumers shop on select sites to provide customers or consumers with the biggest savings available. Defendant owns and operates Honey, that's PayPal. Defendant has partnered with 30,000 businesses or more to include honey in the online checkout process for any consumer who has downloaded the browser extension. These are defendant's merchant partners in the lawsuit. Plaintiffs are content creators with large followings on YouTube. Wendover has 4.7 million subscribers, 240 videos, etc. Wendover regularly partners with businesses, including the merchant partners, to promote products in his videos. He has partnered with businesses such as NordVPN, Ground News, Audible, and Brilliant. When plaintiff promotes products, payment comes from the business with whom he has partnered and who is selling the product. Plaintiff posts videos approximately twice per week, including all videos posted across all channels, and they are all monetized. When plaintiff promotes a product, it promotes it with an affiliate link by which viewers can access the product on the business's website and purchase it if they so choose. The affiliate link tracks how many customers were acquired via plaintiff's content. If you're not familiar with this, if you click on a link from one of these YouTubers with like a buy this product, they review a product and they have a link to buy the product, that link might go to an official website like BH Photo Video for a video camera or something like that. But when you click on a Gerald Undone video with an affiliate link, it goes to BH Photo Video / something that tells it it's coming from Gerald Undone or from some other YouTuber's Wendover Productions video. If you manually removed that tracking code, which is just a tracking code, affiliate code, part of the URL, if you manually remove it, you will still get to the product page and you will still be able to buy the product or service. And the influencer / YouTuber, whatever, will not get the affiliate income. This is what Honey was doing, allegedly, is changing that affiliate code to their own affiliate code so they get the affiliate income even though you got to the website through a different affiliate. Like they said in the video, it's like if you go buy something from a salesperson on commission and right before the salesperson gets their commission, some other salesperson comes along and takes the commission. It's shady at best and illegal at worst. The affiliate link tracking is necessary in determining how successful plaintiff was in driving traffic to the business's website and acquiring customers. Plaintiff's contractual business partners regularly evaluate whether plaintiffs are overperforming or underperforming regarding the business's benchmark for average customer acquisition costs. The businesses track how many customers have been acquired via plaintiff's affiliate link and divide that number into the flat fee paid to plaintiffs to determine if customer acquisition is less or more costly via plaintiffs than the average. If plaintiffs are overperforming, if the business acquires many customers through the affiliate links, then that business partner is more likely to renew contracts with plaintiffs and offer him better terms on future contracts. The affiliate link tracking, therefore, plays a crucial part in defining the future business relationship with plaintiff's business partners. Affiliate link tracking relies on last-click attribution, which is a model that credits the last touch point a customer interacted with before making a purchase as the cause of the conversion. So converting to a sale, who's the person or entity that the customer last interacted with that causes the sale, they get the affiliate income. But here Honey is taking it instead. Last click attribution is the industry standard and is the model by which all or most of plaintiffs' business partners operate. Last click attribution relies on affiliate cookies to notify businesses where certain sales originated from. Plaintiff Businessing runs a similar operation but with separate categories of influence. One, Ali Spagnola's Fitness Outrageous, has over 50,000 subscribers on YouTube. Another, at Ali Spagnola, has approximately 2.25 million subscribers for Ms. Spagnola's outrageous art and outrageous music for outrageous people. Businessing has similar affiliate agreements with third parties. Defendant takes advantage of last-click attribution by inserting a Honey pop-up at checkout for each customer that has installed the Honey browser. If the customer clicks on the Honey link after clicking on plaintiff's affiliate link, then defendant's affiliate cookie replaces plaintiff's or that of any other content creator who uses affiliate links. And this is the big freaking deal. In other words, if a customer clicks on one of plaintiff's affiliate links and then directly purchases the product, the business will see that the sale originated from plaintiff's affiliate link. However, if the customer clicks on plaintiff's affiliate link and then the Honey pop-up, then the business tracks the sale as originating from Honey, and plaintiff will receive no credit for the purchase. Honey erases plaintiff's affiliate links and replaces it with one of its own. If the consumer clicks on the Honey pop-up at any point during checkout, Honey will receive credit for the purchase even if it did not provide any discount codes to the consumer. Even if it did not provide discount codes. Because Honey disrupted the last click attribution for clicks that should have been attributed to plaintiffs, plaintiffs were responsible for customer acquisition that was unable to be tracked by his business partners. Because Honey disrupted that last click attribution, plaintiffs' performance in regard to customer acquisition has been artificially and negatively skewed. Defendants' actions prevented plaintiffs' business partners from counting all customers that were acquired via plaintiffs' affiliate links. Defendant is aware that its Honey browser extension takes credit for customer acquisition for which it is not responsible, and for which, were the Honey browser extension not in place, plaintiffs and other content creators would be properly credited. Defendants' actions have damaged plaintiffs' relationships with business partners. Defendants' actions have caused plaintiffs to receive less favorable contract terms from his business partners and or led to a failure to renew contracts with business partners. So, in other words, you're tracking your business. How good is your business? How good is your marketing? This is a big deal. If you're not getting a return on your marketing dollars, you need to change your marketing efforts or you're just wasting money. And it's really easy to waste a lot of money on marketing or to lose a lot of money when marketing didn't go the way it was supposed to and your good product or service doesn't get the attention it deserves. This is a big freaking deal when one company interferes with another company's ability to make money in an underhanded, misrepresenting, fraudulent, scammy way. It is exactly deserving of a class action lawsuit, and I'm really glad to see that this is happening. I'm sure PayPal will have its own defense. I'm not saying that this is an easy win. We'll go over that in a moment. Defendant benefited by disrupting last click attribution, which should have been attributed to plaintiffs by receiving credit for customer acquisition. Because defendant received credit for customer acquisition, defendant benefited at plaintiff's expense. They're setting up some kind of unjust enrichment argument, even if it's not an explicit claim. Now they're going to attack PayPal as a class. So obviously everyone knows what a class action lawsuit is in concept. Multiple plaintiffs sue one defendant. In any class action, the proposed leader of the class needs to make a argument for why they should have a class action, why they should lead the class, etc. So you have to define the class, and you have to define the class in a way that limits the scope of the case to the appropriate people, not more people than were affected by Honey and not less. So the class is defined as all persons, which includes companies, from December 29th, 2022 to the time of class certification. Why? Because there's probably a 2-year statute of limitations on these kinds of allegations. All persons who contracted with any business to promote a product or service and provided to consumers an affiliate link that led consumers to a checkout page which incorporated the Honey browser extension. So going back 2 years, anybody who did affiliate link whatever, I may be in this class as well because I've had affiliate links, especially with Audible. Not sure if Honey was doing anything with Audible, but we'll find out about that. Excluded from this class are employees, officers, directors of defendant, attorneys appearing in this case, any judge assigned to hear this action. Normal. The questions for the class are, did defendants' policies and practices effectively steal attribution from members of the class? Did defendant profit from customer acquisition, which was otherwise generated by members of the class themselves instead of defendant? Did defendants' actions in stealing attribution damage the creator's relationship between defendants, merchant partners, and members of the class. Whether defendant intentionally damaged the relationship, because intentionalness, willfulness, will multiply damages or potentially lead to sanctions. Plaintiffs are adequate representatives. Yeah, I think so. I think we'll see in a moment who's behind this. If you don't know already, it's kind of fun. It's Wendover Productions, but it's also the damages sought by each member are such that prosecution would prove burdensome. Yeah, it's too complex for the courts to handle every single lawsuit. 30, 50, 100 different lawsuits when you could have 100 plaintiffs in one lawsuit instead. So they are asking, in their causes of action, these are the claims: intentional interference with contractual relations. Defendants knew contractual relationships existed between plaintiffs and the merchant partners. Defendant knew its merchant partners collaborated with plaintiffs and drove traffic to merchant partners' websites via affiliate links. Defendants' conduct prevented performance of plaintiffs of their contractual obligations or made performance more expensive or difficult. Defendant intended to disrupt the plaintiff's performance or knew their actions made things more expensive or difficult or impossible. Defendant's interference harmed plaintiffs by artificially and negatively skewing the data regarding customer acquisition via affiliate links, causing members of the class to appear to merchant partners to underperform relative to actual customer acquisition. Defendant's conduct was a substantial factor in causing plaintiffs harm, and the class. And by virtue of the foregoing, plaintiffs and members have been harmed in an amount that exceeds $5 million. That's the class. It could be proven to be much more than that. The second cause of action, intentional interference with prospective economic relations, it's going to be relatively the same thing. You interfered with existing relations, you interfered with prospective relations, another $5 million claim. Basically, if we're underperforming as YouTuber influencers, as social media influencers, you're not going to hire us. You're going to hire us for less money, or you're not going to hire us. So therefore, you've interfered with prospective economic relations. Injunctive relief. Plaintiff also seeks injunctive relief, which is appropriate where there is a threat of continuing misconduct. These paragraphs themselves are not going to be enough to get injunctive relief, so we're going to see a motion for the injunctive relief for a preliminary injunction very soon. I guess whenever they feel like it. But a motion for preliminary injunction to ask the court to order PayPal or Honey to stop conducting operations like this while we have the litigation. So they're asking for, in their prayer for relief, proper class action, an award of damages, actual damages, nominal, consequential, punitive, exemplary damages, as allowed by law, to be determined at trial, a permanent injunction ordering defendant to stop replacing affiliate cookies and links, prejudgment interest, post-judgment interest, statutorily enhanced fees, attorney's fees, costs, litigation expenses, all other findings and determinations identified and sought, leave to amend, and any other relief. And it is filed by Christensen Law Group, EKSM, and Legal Eagle. The Eagle Team LLP, Devin Stone right there. So I think that's pretty awesome. We go up to the top there. You can see all of their official everythings. Looks like it's a multi-attorney effort to hold PayPal accountable for what they've been doing. I did not know that they were doing this. It sounds like everybody else didn't know they were doing this, and those that found out about it quietly ended their relationships with PayPal/Honey. In that sense, I don't mean that nobody ever used PayPal again. I'd love it if I could stop, but it's a large company, and so this is a kind of a David and Goliath situation. Even large influencers like Wendover are still in the dark that this was happening until it was revealed when someone found out that this was happening. So Wendover Productions doesn't have to have a contract with Honey or terms of service with PayPal or whatever. Even if there's no contract between the plaintiffs and PayPal for this, for influencer sponsorship or whatever, they were also altering affiliate links based on the user having the extension. So if the user could view something on YouTube and then go to try to purchase it and be using Honey, and Wendover has nothing to do with Honey the entire time. So yes, that's a very good point. The contract doesn't matter. I'm looking forward to seeing this play out. I doubt PayPal will settle, so I hope it's not a quiet settlement, but rather like a loud win. At the same time, you'll also notice the lawyers, the way we conduct ourselves when we're not representing someone is different from the way we conduct ourselves when we are representing someone. Um, I can talk a heck of a lot more about the Wendover Productions lawsuit than probably the lawyers that are involved. Of course, Legal Eagle's going to make a video, but it's going to be very carefully made because he has to be very careful what he can say. You don't want to say something pre-litigation that can then be brought into the litigation. Um, a video that Legal Eagle makes or whatever, all of that could end up being evidence that is discoverable during the litigation and could be discussed as part of a trial or a summary judgment motion. It could be something brought up before a jury. So you have to be very careful. That's one of the reasons I'm making this video, is so you can see what my impression was separately from the attorneys actually involved, who will be acting on behalf of their clients first. That's their fiduciary duty. So, very interesting situation. I hope it's something that works out for the plaintiffs, and it will be enjoyable for all of us to watch and follow and learn. So I hope that you found that interesting. Let me know what you think in the comments below. Oh, and Happy New Year.